has a significant substance abuse problem who clearly continues to operate on the roads of our streets.
What is your goal, Mr. Easterly?
The judge should avoid interruptions of counsel in their arguments.
Hello and good morning. Hello, Ms. Fabel-Webb, if you could unmute. Okay, we're calling the matter of the City of East Lansing versus Jennifer Fabel-Webb, case number 24-03080T. We are set today for a adjourned sentencing hearing. May I have appearances, please, for the record?
Good afternoon. Good morning, Your Honor. Robert Easterly on behalf of the city.
Melissa Vachon on behalf of Ms. Fabel-Webb, who appears separately by video.
Okay, thank you. Ms. Fabel-Webb, can you please confirm, are you able to hear and see me and the attorneys?
Yes, I am.
Okay,
Jennifer Fabel-Webb.
So we are here for an adjourned sentencing hearing, our last sentencing hearing. Ms. Fabel-Webb raised an issue as to her information she received about the length of her driver's license suspension. We adjourned the hearing for her to talk to counsel and consider a motion to withdraw plea. I'll begin with you, Ms. Vachon. Where are we at in terms of that consultation?
Yes, Your Honor. I think prior to entering the plea, the consequences we discussed are that it either be a like period or 30 days if not definite. And that is outlined in MCL 257.904. Due to the information Ms. Fabel-Webb received from Secretary of State, she was under the impression that she was eligible for a permit and not serving any definite length of revocation or suspension. Subsequently, she received a notice that her license is now revoked until 2029. I don't think it would be in her best interest to withdraw her plea today. However, she would like to do so. So I believe that under the court rule 6.310, if the court would allow her to make her own motion to withdraw her plea, I think the court could find grounds to do so. Would be against my advice though, but she does want to continue with plea withdrawal.
Okay, Ms. Fabel-Webb, you've heard what your lawyer just told me, correct?
Yes, I did.
Okay, and is what she telling me accurate?
I know she said that there was other consequences of obviously what could happen. I didn't realize it was totally against her advice. But I did hear her say that there could be other lengthy issues. However, when I did take that plea, I did be referenced to being only suspended for 30 more days. So that's why I had really based this on that. And when I got that information, I thought, if there's anything I can do to work around this so I can get my license, because this will disqualify me again for so long and put me right back in the same issue, I'd be indebted and grateful for sure so I can get that done.
Okay, and you understand, of course, Ms. Vachon has no power or authority to offer you a plea agreement or change that. That is through the City of East Lansing. And so
I do now understand that. I didn't quite understand how it was working before.
Okay, but now you do understand. So if you withdraw this plea, Ms. Vachon will not be the person who will be offering you anything. It again is the City of East Lansing.
Correct.
Okay, would it be helpful to the parties? The court has reviewed Ms. Fabel-Webb's driving record, and I can offer, again, not any legal advice, but I can offer the information that has been provided to me. And Ms. Fabel-Webb, then you could have more information to base this decision. Okay, so Ms. Fabel-Webb, you are revoked. And your driver's license is revoked because of your having 3 operating while intoxicated offenses within 10 years. Okay, so you understand that, right?
That it was revoked, yes.
Yes, okay. So then when you are revoked and you continue to drive and you have another traffic offense, that what was a 1-year revocation period turns into a 5-year revocation period.
Okay,
Okay, and for my information, we have this case here where you entered a plea, and that's what we're talking about today. And the disposition date is October 11th of 24. And so because of that plea, you were revoked and you entered another plea to a traffic violation that turned a 1-year revocation into a 5-year revocation.
Right.
Okay. However, Ms. Faba-Webb, also, after you entered this plea, you also pled guilty in another court, in the 78th District Court in Baldwin, to another traffic violation. And so that also, on its own, would have turned, well, I'm looking at the information right here, Ms. Faba-Webb.
never pled guilty to anything there.
On November 27th, so after this case, November 27th of 2024, you haven't had any court dates and
I just had an arraignment for that, and it was for allowing this non-licensed driver to operate. It wasn't a driving on suspended, is what I was understood, and I did
Okay.
not plead guilty to that.
it was a failure to signal and or observe, and it was a plea of guilt. And again, this is per the Secretary of State's records.
I just seen them and I did not plead guilty with that. And they told me that the charge was it wouldn't even go to the Secretary of State. However, I do understand, but I did not plead guilty to that. I just seen them. I just had an arraignment. So there was no plea. I have to go back to them.
You definitely need
told
to
me
go
it
back
was-
to them.
Yes, they said that it was a allowing an unlicensed or suspended driver to drive a motor vehicle.
Did you
Is
have
what
an
they said.
attorney in that case?
I do not yet. They have a attorney set up for arraignment hearings, they said. I made sure I was aware because I seen that they had used an attorney, but they do that for the arraignments to get the arraignment process to help each side understand what the charges are and whatnot. But I never put a plea in. I haven't got an attorney yet. And I told them that if this is the charge and this is that, then I would just represent myself. So I wouldn't have to, further get any, another attorney involved or any of that because of what they stated that the charge was. And
Okay, so none of that is making sense from the information, the record I have before me. So there's a significant,
yeah, we need to check into
issue
that
with
because
the
I have a
78.
witness. I have a witness right with me here that can tell you that I did not enter a plea and I was just there to be arraigned.
Okay, so, and that's relevant because as I was explaining, this case in Baldwin would have, again, on its own, irrespective of our case here today at 54B, would have converted a 1-year revocation to a 5-year revocation. So if that case in Baldwin stands per the information that I have in front of me, well, you don't have, I mean, it doesn't help to keep saying no. It's what I have
Well,
in front of
I
me.
never took a plea and they told me it wouldn't go to Secretary of State. That's
Okay.
exactly what they said.
Okay, so if Ms. Faba-Webb is correct and this can get fixed, then the case here does matter. Then this case is what is going to convert a 1-year revocation to a 5-year revocation.
Correct.
So, Ms. Vachon, do you want to comment on any of that information?
And I just note that while this case was pending, Ms. Faba-Webb was told that she was eligible to get a permit and then a license by the Secretary of State, which is inconsistent with being revoked. So I'm not sure if there's some confusion with Secretary of State and the driving record. I just don't see how a withdrawal here would help the situation. I'm concerned that it would be sent for a driving while license suspended seconds, and that is my main reason for advising against a withdrawal. But
And that would be through Ingham County, correct?
Yes, I do understand that she does want to withdraw her plea, and I think court could allow her to do so.
Okay, but if I have no idea, but if Ms. Fable-Webb, I'm talking to Ms. Vachon now. If Ms. Fable-Webb is correct and this case in the 78th District Court is not a conviction, then this case, our case, is what is converting a 1-year revocation to a 5-year revocation. And I think we can all agree that that is a significant prejudice to Ms. Fable-Webb. I mean,
I don't agree. I don't agree with that at all, Judge.
okay.
And I'd like to be heard. There are a couple of things I'd like to address, and I think the court adjourned this and specifically asked that the city attorney be here to address a number of things. And so I'd like to take the opportunity to do that right now. The first thing I'd like to point out is the procedural history here. This case was filed in May of this year. She was arraigned in June of 2024. She failed to appear for a pretrial late June. Bench warrant was issued. She later appeared in July for an arraignment. That bench warrant was canceled. To my knowledge, there weren't any sanctions for that. In a couple of days after that, Ms. Fable-Webb contacted the court.
You mean in September 12th? When the bench warrant was?
No, Judge. That would be June 27th. She failed to appear for a pretrial. July 18th, she appeared for an arraignment and the bench warrant was canceled. A couple of days later, she telephoned the court to request the date and time of her next hearing, which is a little bit strange because she had just been here a couple of days prior to that. On August 15th, a pretrial was held, which does not require personal appearance per the policy of this court. It was set for a final pretrial. On September 9th, a pretrial was held and the defendant failed to appear and a bench warrant was issued. She later contacted the court and indicated that was due to a family emergency. The court asked her to appear the next day. She informed the court that she could not. The court then said that the bench warrant would remain until she did appear. However, 2 days later on its own, the court canceled the bench warrant. I don't believe there was any sanctions tied to that.
Because she provided proof of her mother's death.
Thank you. On October 11th, it was set for a final pretrial, but a plea hearing was held. On November 13th, she failed to appear for a sentencing. On November 14th, an arraignment on the bench warrant was held. I don't believe there were any sanctions for that. On November 20th is the last hearing that occurred, and which is why we are here today. I'd like to point out, first of all, and I did order the transcript for that. The court indicated on page 3 that we set the sentencing out for Ms. Fable-Webb to make efforts at clearing her license. That is not why the sentencing was set out. I was at the plea hearing, and what I requested was that there be a PSI for her sentencing hearing because of her very, very significant criminal history. That is why a sentencing was adjourned. There wouldn't have been any point, from my perspective, for a sentencing to be adjourned for her to continue to try to get a license. She'd already entered a plea. Further, as I had already advised Ms. Vachon a couple of times, that I know factually that Ms. Vachon had also advised Ms. Fable-Webb, she had been, her license is revoked, and it's not for a 1-year period. And I just want to place into the record here exactly what we're talking about. She has 6 prior OWI offenses. She has 4 prior DWLS offenses that I can tell. She has 2 prior fail to stop and identified for for property damage accidents, and she has at least 4 prior controlled substance convictions that are not OWI related. As a result of that, and I don't know exactly what this court's experience is with, and I do license revocation several times a year. She is revoked indefinitely. When Ms. Vachon at our very first pretrial, when Ms. Vachon informed me that Ms. Fable-Webb told her that she had a meeting coming up soon with the Secretary of State, I informed her via email, and several times thereafter that was likely impossible based on what her history is. She would have needed to been fully engaged in a license restoration process. Having done both defense and prosecution work, I understand sometimes even with the best of advice, clients are not completely honest with where they are. And so what we did grant several adjournments for there to be progress made. I think that Ms. Fava-Webb has been disingenuous with this court along the way in terms of what her progress has been. I think she's been so with her attorney, but that's, I don't know what I can do about that. But to the extent that we adjourn this for her to try to go get another license, that's not what occurred. I'd also like to address that.
Well, Mr. Easterly, you were at the plea, correct?
I was indeed.
And the court did not order a PSI.
From what my recollection is, the court asked if we were ready to move to immediate sentencing or if there was any reason that sentencing should be set out. And I said, to my recollection, that it should be set out for the court to review this case.
Okay. Well, a PSI was definitely not ordered. It was not stated on the record, and then sentencing was adjourned out to review this case, and it was set for remote sentencing. Okay.
And so then again on the 20th, it looks like, Ms. Fava-Webb made this statement to the court about a 2028 date. I'm not quite sure where that came from, but the court also asked at that time whether or not she had a license. I think that's probably the first time that I've experienced. I guess the court maybe didn't have a copy of her driving record at that time.
I have it now, and I did verify that that's what the Secretary of State said of what was going to happen with this plea, and 2029 was the correct date.
The court asked, and I'm referencing page 7 of this transcript. The court asked Ms. Vachon if, in her experience, if this is a typical resolution. And again, the plea that the court had already taken was for her to plead guilty to a DWLS first, and the city would dismiss a civil infraction. Now, whether or not it's a typical resolution, we don't have those. It's based on a case-by-case basis, although there's kind of a plea matrix we use from. We have to look at the specifics of each case. And in a case where a person is revoked indefinitely based on 6 OWI-related offenses and continuing to drive thereafter with multiple DWLSs, I think that what was offered to her was absolutely fair and appropriate.
What is your goal, Mr. Easterly? What you brought up all of these failures to appear, and she wasn't sanctioned, and what do you want? Just let me ask the question. What do you want the court to do? Are you asking for Ms. Fava-Webb to be incarcerated?
The first thing that I would ask the court to do, I know based off of its recent invocation, the court is aware of the judicial canons. I point to judicial canon 312 that a judge should avoid interruptions of counsel in their arguments. So I'd like to get through this. The court asked for me to be here today. There's a record that the court made making requests of the city attorney to make explanation of what it is that was going on with this plea, and that is what I would like to do.
Okay, and I just want to say I never asked for a procedural history of Ms. Fava-Webb's failures to appear, and don't really see the relevance of that. We're trying to get to the matter of Ms. Fava-Webb is maybe requesting to withdraw her plea, and what is the city's position?
That's not where I'm at right now, Judge. Thank you. May I continue?
And where are you at in terms of, you want to explain the plea offer? You want to explain your plea offer?
I'm addressing what this court addressed in my absence of the last hearing, and specifically asked and referred to that the city attorney explained. Is that correct?
Explain the plea offer.
So this court asked whether or not this was a valid plea, and I guess I'm not sure what that means. The court took the plea according to the Michigan rules of court. We were at a time that was scheduled for sentencing, and so I guess I'm not totally sure what it is that the court was asked. So a valid
plea needs to be made on accurate information. And so that would be referring to Ms. Fava-Webb had raised an issue at sentencing that she did not receive accurate information about what significant consequence of her plea. Her attorney was present. This would have to do with the relationship between counsel, defense counsel, and defendant. not the city. And a valid plea would be one that was not based on accurate information.
So again, to that point, from the first pretrial, I advised Ms. Vachon of what her status was. I understand that Ms. Vachon also addressed with her what her status was. Again, I feel like Ms. Fowler-Webb's has been disingenuous with counsel and with this court about what her status is. But I also disagree that this is not about the city attorney, because this is, as I look at this transcript, you repeatedly asked that the city attorney be here. It's page 9. You said, I think you need to talk to the city attorney. The city attorney needs to explain whether or not this is in line with the policies and procedures that the city of East Lansing wishes its city attorney to follow for their cases, and that you have a very hard time, this court has a very hard time thinking that this is in the interest of justice. Is the court still of that opinion?
The court is first concerned with the information about, is this a plea based on accurate information? And that's why, of course, the city would need to be present and has a right to be heard under the rules, because there is a consideration in terms of interest of justice and any prejudice to the people. So, of course, you would need to be heard. And then, in terms of the plea offer, which was, pleading to the charge with no, agreement or consideration, you have placed on the record.
The consideration was a dismissal of a civil infraction.
And to plead to the charge, you placed on the record what animated that plea offer to you. The court has asked, given that plea offer, what is the city's recommendation per sentencing here? We have a person, and we have had other people before us who are unable to get a valid driver's license. And the city, what the city does in terms of its plea offers has a significant consequence moving forward on how that person may or may not. In Ms. Fowler-Webb's case, according to the information I have before me, it may be this conviction, maybe, that will turn 1 year where a revocation where she could apply to a 5-year. And I'm not saying that I have, I'm just telling you what has been provided to me from the Secretary of State.
Yes, what's provided from the Secretary of State indicates that she is revoked indefinitely, and that, again, that's based off of 6 prior OWI offenses. She would have to go through a revocation, through a reinstatement process that is not a year out at this point. From the city's perspective, we have a person who clearly has a significant substance abuse problem, who clearly continues to operate on the roads of our streets. And so, what is the city? Do I feel that this was a fair plea agreement? I do. If she wishes to withdraw her plea, then what my recommendation would be is to send this through ICPO for a DWLS second, which will result in a higher sanction on her license.
I don't have 6 OWIs, and I haven't gotten in any trouble, and I haven't on my record that I did obtain from the Secretary of State in 2020, which I was told I would be able to get a restricted license, and things had been changed in my record. And so I obtained a copy of my driver's record. I do have the appeals court going through my application now, because that's what I was told I had to do after I was told I wouldn't have to do that before, and now I was told I have to do that. So I'm just still trying to do all the avenues, and I have not been in trouble and done anything, and I am not under any substances, and I have been clean for quite some time, and I do not have 6 OWIs. So I think that there is there's some different other information. I was there for one of the meetings, and I had been calling and talking with the court all that morning when my first sentencing hearing was established. So I was there to be attended. I showed proof to the court that I was there. Before
I
that,
think we've already addressed all of
Yeah,
those.
that's not
Ms. Pablo Webb.
relevant. You're here today and we're
Okay.
gonna move forward. I would note the last controlled substance crime that I see is from 2020.
Yeah, that was, and it was prior to that, it was convicted, but I was charged before that. So it was even a year and a half route before that.
Right.
And it was a prescription medicine that was not
Ms.
no
Pablo,
longer
we don't have to get
was
into the
outdated.
details of it.
Definitely not.
Okay.
So again, Ms. Fabel Webb, the motion that is being considered is, well, if you are making a motion, are you making a motion to withdraw your plea? Apparently that is against the advice of Ms. Vachon. And, I'm happy if you want to talk to Ms. Vachon for a moment to review any of this new information that's been provided. But once again, what I have, and this is both based on the Secretary of State's record and also consultation with a liaison at the Secretary of State, that it is the two cases, our case here and a case in Baldwin, that is converting what would be the 1-year revocation before you could even begin to reapply and go through, even start that process, to a 5-year revocation. So, Ms. Vachon, do you have any questions about that? And do you wish to talk to Ms. Fabel Webb?
I wish to talk to her, yes.
Okay, so we're going to place you both in a breakout room and then we can come back on the record. And we're back on the record in City of East Lansing versus Jennifer Fabel Webb, case number 2403080T. Ms. Vachon has returned from the breakout room with Ms. Fabel Webb. Ms. Vachon, how are we proceeding?
Yes, Your Honor, Ms. Fabel Webb still wishes to make a motion to withdraw her plea. She's aware of the potential consequences of that. I just want to make clear that I think there is a misunderstanding of the Secretary of State information. Ms. Fabel Webb believes that she will be eligible to take her permit test, which from what the court is stating, I don't believe that to be accurate. However, that's what she was told. When we entered the plea, informed her that it'd be either a like period or 30 days, and she believed that at that time she was not revoked and she was eligible to take her permit test, get her license, and go from there. I think she would need, if she was revoked, she would need to do the reinstatement hearing process, which would take a longer time. However, she was told that she is eligible to take the permit test and then get her license.
Okay, Ms. Fabel Webb, you've heard what your lawyer told me, correct? And we may have lost, oh, there she is.
Sorry, there was a glitch. I'm sorry.
Okay, you're back. Did you hear what Ms. Vachon told me?
I did not get to hear, Your Honor. I'm sorry. I did not get to hear the very end part, but I did hear throughout most of everything to be accurate, but I never knew about the indefinite or 30-day. I didn't know that was that I just was told the 30 days. So that's what I was understood. Besides, I did talk with the Secretary of State, and I do have some stuff that I did get from the Secretary of State also saying what my license would have been.
Okay, so Ms. Vachon reports that you would like to make a motion to withdraw your plea.
Yes, Your Honor.
Okay, and that is for the reason that it's your position that it was based on inaccurate information that you received about the consequence of this plea on your driver's license.
Correct.
And we're looking at the court rule MCR 6310 B, withdrawal after acceptance but before sentencing. What is the city's position? Mr. Easterly, the city's position?
Say that one more time, Judge.
What is the city's position in response to Ms. Fabel Webb's motion?
I think I've already expressed my response. If she wishes to withdraw her plea, that's I leave that to the court. I feel like this was avoidable. I don't think that that's what Ms. Farber-Webb was initially requesting. I think that that was suggested by this court. I also think that we are in a place of recharacterizing what was stated on the record at the previous hearing, which I think is unfair both to the city, to Ms. Vachon from what I'm reading, and now is going to result in possibly a very different scenario from Ms. Farber-Webb. So I defer to the court on her withdrawal.
Okay. I'm not understanding that response. Either you object to the motion, or you agree with the motion, or you're just saying, can you focus on the motion, and you're just saying you leave it to the court's discretion?
I'll leave it to the court's discretion. Which part are you saying you don't understand that I'm saying?
Just that, I asked for the city's response to a motion, and that whole, I didn't understand your response. So,
Okay.
but now I do. You're leaving it to the court's discretion. And Ms. Farber-Webb, a plea can be withdrawn on a motion only in the interest of justice and may not be withdrawn if the withdrawal of the plea would substantially prejudice the prosecutor. Because reliance on the plea, the city is saying that that is not applicable here. They're not claiming any prejudice. What I understand is the city is saying that if you withdraw your plea, that this can be charged as a more serious offense. So the city is not claiming prejudice to the city, but arguably could be prejudice to you. You understand that?
I do understand. I believe I do understand.
Okay, so
I don't
instead,
believe she understands, Judge.
so
I don't believe she.
I guess.
Ms. Farber-Webb, instead of being charged with a 93-day misdemeanor, you could be charged with a 1-year misdemeanor.
I do understand that.
Okay, and you wish to withdraw your plea, understanding that?
I do still, because of there not being clearance throughout this whole situation, and I would like to make sure that I get that resolved along with the court, and I'm just asking for that ability to be able to do that. So there's no miscommunication, no missing of court hearings, no nothing. Just get it, the communication, show the proof of which I seen and what I was told, and get done what I am trying and have been wishing and hoping to do. So
Okay, so with that, the motion will be granted. And Ms. Farber-Webb, that means that this would typically be set for a pretrial. At this pretrial, as has been noted, it's possible that this will be referred to a different prosecutor that would have the authority to charge a more serious offense, the 1-year misdemeanor. So you will take note of that, but we'll get a date for the pretrial. Ms. Horn?
thank you, Your Honor.
Okay, so the pretrial will be on January 9th at 1 o'clock. And Ms. Vachon, will you be submitting an order granting the motion to withdraw plea?
I can, Your Honor, I can submit one if required. I just do not agree with the motion.
Understood, but I think Ms. Farber-Webb was fully advised here, and yes.
Yes.
So with that, that is all for this case. Anything further from the city?
Not at this time.
And anything further from you, Ms. Vachon?